All right. The attendance will be on in a few moments. Yes, it's a very cute dog. All right. A few notes before we get started. First, last class. Okay, the attendance is running now. You can sign in. Last class, I mentioned a few proposals for the exam. What I think faculty, what we're going to end up doing is that for the exams, you'll have a 6-hour window. What that means is you can take it at any point from 3 p.m. till 9 p.m. And the thinking is a 6-hour window reduces the chances of cheating. If you have a 3-hour exam and you start at 3 p.m., you'll finish right at 6. And if you finish at 6, someone else has to start at 6. So there's not much of a gap between the first people finish and when the second people start. So I think that's a more elegant solution. We had talked about it maybe a 12-hour window. And the 12-hour window, I think, was rejected because of fears of cheating. Any thoughts on that? Anything you want to add? Okay. I'd like to talk also about the midterm review sessions. I was with students on Saturday and Sunday from at noon till 5, so it's about 10 hours this weekend. If I had to guess, about 2/3 of the people who were eligible came, and about 1/3 of the people who were eligible didn't show up, which is fine. I can't make you come if you don't want to come. That's your choice. If you had some sort of conflict, you don't need to email me about it. It doesn't really matter the reason why. You're welcome to come next week. Just know you'll be at the bottom of the queue. So it might be 5 or 6 hours till I get to you. The reason why I'm using such a strict approach is I have 125 people. And there's no good way of sorting people. It doesn't work. Keeping appointment slots are impossible because people miss their slots. It happens every year. I found this has actually been pretty effective. I was basically in front of my Zoom for 5 hours straight on the weekend. And as soon as I finished one student, I went to the next. And it was actually pretty seamless. I would keep in the chat what the queue was, so you knew roughly what order you were in. And then if you need to go to the bathroom or leave for a bit, you didn't have to worry too much. I had really no issues. So I hope to see many of you this upcoming weekend for the midterm reviews. I think on Saturday I am doing last name to begin with the letters A, M, or O. It's kind of random. Amo, A-M-O. And on Sunday, it's D, E, and R. So I have 17 on Sunday on the list and 16 on Monday. We'll see how many of those actually show up. Okay. Questions on the exam or on the midterm review scheduling? All right, let me now discuss some of the observations I've had from these sessions, which are very helpful. I very much like meeting with students. It makes me feel like I'm actually still doing my job. I don't get to see you all in person, but these one-on-ones actually make me have some sort of connection to students that I think is just lacking. My goal during these sessions is not just to give you your grade, which I will. I'll give you a number if that's what you want. My goal is to diagnose what went wrong. And usually students are not that cognizant of what they're doing wrong. It's not your fault, but it's very hard to assess yourself. That's human nature. And I found that there are a handful of common, I don't want to say errors because that's not a nice word, but a handful of common habits that students have formed that result in bad grades. And these are things that, once identified, can be tweaked. With some ease. The first one, of course, is timing. On any exam, you won't have enough time, right? In a perfect world, you have as much time as you want, but you don't have a perfect world. If your issue is timing, that you're not finishing, I recommend what I call the stopwatch method, which is exactly what it sounds like, right? On a given question, you have 5 parts, right? If you have 90 minutes to answer 5 subparts. It makes no sense to spend 20 minutes in question number 1 because that leaves you basically 1 minute for question number 5. What I strongly recommend if time is an issue for you is to actually use a stopwatch, right? Or an app on your phone, whatever else you want to use. Give yourself 10 minutes per question. Maybe 11 minutes, but my recommendation is 10. And at the 10-minute mark, stop. Wherever you are, stop. I don't care if it's mid-sentence, stop. Because if you go, oh, let me write one more sentence and another sentence, you've gone 15 minutes. Stop mid-sentence. Go on to the next question. Give yourself at least the same amount of time per question. What does this mean? When you're doing a practice exam, bring a watch with you and see what it feels like to stop at 10 minutes. It's going to feel awkward. But soon you'll start to realize, okay, I can actually do this in 10 minutes. And your time can be used more effectively. So the stopwatch is your friend if your time's a problem. Not just for my exam, for the bar exam, whatever. If you have a bar exam question and you have, say, 5 essay questions and you have an hour, spend maybe 10 minutes per question. You cannot afford to spend 20 minutes in question number 1 because you have to rush question number 5. I can't tell you how many people fail the exam because their first answer is really long and their last answer is bitty, right? It's tiny. I know what happened. You didn't budget your time properly. You think, oh, I'll get to it later. No, you won't. You'll run out of time. Okay, so that's number 1. Number 2, people get freaked out by the word limit. You really shouldn't. Students love to complain about the word limit, but that merely masks the fact they don't know what the actual answer is, right? If you can't write a concise answer, I mean this with love. If you can't write a concise answer, you don't know what the right answer is. The questions are written to have a very precise set of answers. They're written to be answered in 200 words. If you need 500 words to answer it, you're wandering through the wilderness. You're throwing spaghetti at the wall trying to get something that fits. Don't do it. I say this all the time. Supreme Court briefs are 6,000 words. You don't need more than 1,000 to write an exam answer. You don't. It's just not necessary. Here's one way to work on your word count. Law students develop a habit. I won't call it a bad habit, but it's a habit of preparing canned answers. That is, in their outlines for an open book exam, they'll just write things that they think are relevant and then just copy them into the exam, regardless what the question is asking. Don't do this. I know very quickly if there's a canned answer because you're having sentence after sentence that has nothing to do with the exam. Every sentence you write should be based on the fact pattern. It should not just be random rule statements in the abstract, right? If I'm looking at your exam and there's like 80% rule statements that are generic and like 20% analysis, you're in bad shape. Flip it, right? Have maybe a few rule statements at the beginning and then make the bulk of your analysis yours, right? Make the bulk of your paper your analysis. You're going to be in such a stronger position, not just for me, right? The L or W professors hate when I say this, but it's true. I rack as a crutch, right? It's something to help you get going as a 1L, but you're not going to use it ever again. I promise you won't. I'm sorry. It's true. You're not going to use it, right? The R and the A become merged, right? If you're a good legal writer, like think of John Roberts, a good legal writer. He does it so effectively you don't even see it, right? The R and the A are just blended together. You never know what he's talking about, right? Good legal writing applies the facts at every juncture. You're not just stating rules in the abstract indefinitely. You can do it, but your focus is analysis. So if you're blown to the word limit by just copying rule statements from your outline, don't do that, right? Give me the answer, not just your rule statements. You'll find, oh, wow, yeah, you can do this. I've given the A+ paper, people write 800 words. They didn't even use a full 1,000. It's possible. You can do it. You don't even need all 1,000 words. It's just not necessary. A lot of students got tripped up by the time frame. Now, I said many times in class, do not cite cases from later. I can't tell you how many times I said it, and a lot of you just ignored it, or didn't remember, or didn't care. I don't know. I said it many times. There was never a mystery about this. A lot of you just start citing Justice Jackson in Youngstown, even though it's 150 years later. Fine, make the mistake in the midterm, don't make it in the final. Now, people say, oh, but Josh, how do we write an exam in the year 1800 when there are no cases? Well, that's the point, right? I'm asking you not about the Supreme Court cases, but about the Constitution itself, right? The Due Process Clause, Fifth Amendment, was in the Constitution in 1791. Takings Clause as well. If the president is locking up Indians without any sort of proceedings, you know that there's probably a due process problem. You don't need quorum to tell you that, right? If the executive is seizing property without paying compensation, it's unconstitutional. You don't need Youngstown to tell you that, right? The reason why I ask these questions is to focus you on the Constitution itself without being clouded by a century of Supreme Court precedent. Right? So again, it disappoints me no matter how many times I say something that people make the same mistake. It's disappointing, right? They make excuses, whatever, but just don't do it, right? I'm laying it out for you as clearly as I can. The word count, a lot of you just didn't know how to use the software. Technology is a requirement. If you don't know how to use it, ask for help, right? There's a little document icon by the word count. If you click the document icon, little page, right? Word count pops up. Most of you got it. A couple of you didn't. If you didn't get it, you have a finger. I know it's not super, but it doesn't take very long to do a word count. To count to 1,000 or 500 or 600 takes maybe a minute or two. But technological competence is a necessity. There was a time where people said, well, I don't like science or technology, so I went to law school. Yeah, that doesn't work anymore, especially with Zoom. Lawyers have an obligation to be technologically competent. This is not about the word count, but in general, we need to put a bigger focus in law school and teaching you this stuff because you're going to be expected to be able to be tech savvy, right? You can't always depend on an IT department now when you're working from home, right? This is the world you're going into. Okay, I think those are the highlights of the meetings. I'm trying to think of anything else. Anyway, yeah, come prepared. Come prepared. Be ready for the meeting. Make sure you're prepared. If I sense that you didn't put your all into the practice midterm, I'll ask you to do it again, which you're not required to do. I can't make you, but I strongly encourage you to do it. Okay. Sorry for being harsh. It's frustrating, specifically with the cases in the years where you say something over and over again in class and just people do the opposite. It does get frustrating because I put a lot of precision into how I lay out the lectures, and just certain things just pass and just aren't heard. This semester counts. Last semester didn't count for you. And the 3L grade, the third semester grades are going to be very important for a lot of you because you have no grades from your second semester. It really puts you at a disadvantage. I don't envy you. I think this generation of law students is in a very precarious position because you have this sort of break in your education, and then these grades are very important for the semester because they will largely dictate hiring for various jobs. Right? There was no full recruiting in September, so you can have it in January. In fact, that's why I have to grade quickly, as they say. They compress my grading window, so you should have your grades. I think the deadline is January 4th. Which is usually it's by January 15th or so. This year it's January 4th. So your exam, I think, is like December 15th or is it 17th? Might be off by a few days, but it's towards the end of the period, so it's going to be a very compressed window. Okie doke. All right. Sorry for being dour, but it was a long weekend, and a lot of people made the same mistake. So my hope is to convey them publicly to the entire class, and that makes it easier with the one-on-ones. It's much easier for me to yell at a screen than to yell at people one-on-one. I don't like yelling. I don't enjoy it, but sometimes I have to be a little bit more tough to get the message across. Okay, anything else? All right. Let's start our materials for today. We are continuing our discussion of the Due Process Clause. I'm sorry, of the 14th Amendment. In our last two classes, we did the Privileges or Immunities Clause of the 14th Amendment, and we did the Equal Protection Clause of the 14th Amendment. Right? With privileges or immunities, we covered several cases. We covered Slaughterhouse. We covered Bradwell. We covered Cruikshank. And with the Equal Protection Clause, we covered other cases. We did Strauder versus West Virginia. Excuse me. We did the civil rights cases. We did Yickwell v. Hopkins. And we did Plessy. And in almost all those cases, the court adopted a very narrow reading of the 14th Amendment. The 14th Amendment's Privileges or Immunities Clause doesn't really protect anything. It's kind of this meaningless provision now. And in Plessy, the court adopted the separate but equal doctrine, right, where you can have racial segregation. It's perfectly constitutional. Right, so again, both privileges or immunities and equal protection were very narrowly constrained. Okay. But there was one provision of the Constitution that wasn't really interpreted during this time. Right? Which is the Due Process Clause. There were just not many cases involving the Due Process Clause. So one of the weird historical accidents is as the court sort of constrained the reading of privileges or immunities and constrained the reading of equal protection, the court expanded the meaning of the Due Process Clause. And it's this weird historical accident that the Due Process Clause became the basis of almost all of modern constitutional law. We'll spend the rest of the semester, except for maybe 1 or 2 classes, on due process, right? Almost everything will be on due process. And that's because the court strangled privileges or immunities in its crib. It was really the PRI clause that was meant to be the heart of the 14th Amendment. That was actually the most important provision. But Slaughterhouse ended that quickly. Okay, so let's start with the question. It's a poll question. Short answer. Number 1. What does it mean for law to be arbitrary? What does it mean for a law to be arbitrary? Okay. Who is next on the queue?
I think I might be. I think Emily was last.
Okay.
This is Catherine.
Okay. All right, Catherine, what does it mean for a law to be arbitrary?
I said that it means that it's without justification and just passed for no reason at all, really, which makes it, as you said, not really a law.
What do you mean not really a law? I know I said that in the book, but what does that mean? I think I said that today.
I guess that there's no, I guess to analyze it as some of the justices do, that the means doesn't really justify the end. If the reason that they've stated that that they put this law into place is not really the end result, then there's no reason for it.
Yeah, Catherine, let me ask you a follow-up question if I can, please. Why does a law have to have reason behind it?
be fair, I guess.
Why does the law have to be fair? I feel like I'm a little kid. Why, right? Why does the law have to be fair? Why does the law have to be fair? I know, you never thought about this, right? I'm trying to go a little bit deeper. Macy, I think you're next. Macy, let me ask you the question I put to Catherine a minute ago. Why does the law have to have reason? Why does the law have to be fair?
I mean, why else would you have a law if it wasn't going to have any reason?
Well, maybe because the person in charge thinks it's a good idea.
They would have a reason for it.
Yeah, he likes it. That's the reason. He likes it. Can't really explain why. Why does law have to be a reason? Right? Why does it have to be a reason by law? I realize this is a very hard question. You've probably never thought about this.
So that's the role of the government. If you're making the law, you've been put into the position of being a lawmaker, and the whole purpose of government is to provide like reasonable bounds for society.
Why though? Why? Why is it the whole role of government? I keep drilling deeper into your answer. Why is it the whole role of government?
Because otherwise our society would be chaotic.
So what? What's bad? What's so bad about chaos?
Nobody wants that.
How do you know?
Okay, reasonable people.
Oh, reason again. Here we go. Well, let me... thank you, Macy. Very good. I love these questions. We'll hate them. Has anyone ever read the story The Lottery? You ever read it? Just raise your hand if you read it. It's a short story, maybe read it in high school or somewhere. No one? Usually there's usually one or two people who've read it. Okay, that's fine. Well, I'll give you a brief recap. It's a short story, but I'll give you a summary. So you have a small town in America that has about 300 people, and every year they have a tradition to ensure a good harvest. Right? It's called a lottery, and every year they have a lottery to ensure there's a good harvest. Right? And here's the way it works: where every year, every family pulls a little slip of paper out of a box, and one of the pieces of paper has a little black mark on it. Okay. So this one night, the Hutchinson family pulls a little slip of paper with a black mark on it. Okay, so that's round number one. And then you have round number two. Each member of the Hutchinson family pulls another slip of paper out of the box. And one of those papers has a black mark on it. Right, so the husband pulls it, the son pulls it, the daughter pulls it, everything's fine. But then the wife, Tessie, pulls it. Right? She pulls a slip with a black piece of paper on it. It was completely random. There was no cheating involved. It was a fair, random draw. Okay. After Tessie pulls the slip of paper from the safe, she goes to the town square and she's stoned to death. Everyone throws stones at her. And as the rocks are flying at her, she says, "This isn't fair. This isn't right." Whoa, right? So the question I want to ask you all, and we're going to spend some time on this one. Number two, the odds would be forever in your favor, Hunger Games style, right? It's actually not like Hunger Games for reasons I'll explain in a minute. But question number two is, the lottery is fair, yes or no? There's not a right answer to this one. I want to see where all of you fall. I want to see how the percentages break down. The lottery is fair. I think Denver, you're on deck in about 15 seconds.
I guess you mean a lottery as you told the story, this particular lottery.
Yeah.
Okay.
That's the name of the story is a lottery, exactly. Oh, the actual lottery we scratch off the things? No, that's not fair. That's a ripoff. Right, that's a scam. Sorry if you play lottery. I've never bought a ticket in my life.
I want to buy a ticket, but because of the scam part, it stops me from buying the ticket. I have dreams.
Yeah. To be a millionaire. The rates of bankruptcy, my friends, for the lottery winners is staggering. It's basically the state gets the money back eventually, right? People who win that, not to be mean, don't spend it wisely. And they get, caught up in, scams and people take advantage of them. In some states, you're allowed to actually accept the money anonymously. But in other states, you're actually required to make a public appearance, with the huge, ginormous, oversized checks, right? And then, once people see it, it's a mark for a scam. So I have no interest in the lottery. Dreams, but I'm good. All right, so I think the numbers are settled here. Denver, what do you think the answer here is? Is this a fair? Is the lottery fair?
Fun one.
Yeah, fun one. Yeah.
So I'd say it's fair, but I wouldn't say it's just.
Okay, so let's do one at a time. Fair and just. Why do you think it's fair?
I'd say it's fair. I looked at the Black's Law Dictionary.
That's a good place to start.
They're characterized by honesty, impartiality, and candor, just, equitable, disinterested. So aside from just, it's disinterested because you're just pulling stuff out of a hat. Anyone has just as much of a chance to get stoned to death. So I think it's impartial.
So you think it's impartial, it's fair, that there's no bias, that anyone can pull the paper out of the box.
Right.
Okay, but you said it's not just.
Yeah.
What do you mean there?
People should get stoned to death randomly in the middle of the town square necessarily.
Why not?
A way to run your society.
Why not?
It doesn't sound like a place I would want to live necessarily.
But the people there seem very happy about it. In fact, it's necessary for their harvest. That's the setup I gave.
Right. Yeah. Yeah, it's tough. I don't know. I don't think it's great to stone people to death for some random reason.
Random, right?
Yeah.
But isn't random fair?
Right, but I think so. I'm going to assume it's some kind of religious reason that they're doing this, or they think something.
I heard nothing about religion.
Or if it's just harvest party, that's also problematic.
All right.
You separate that from the way you run your society, and then you stone people to death.
All right, David, are you here, David?
Yes.
David, what'd you put here?
I said it's fair. Zeroing in on the wife, they lived in this community, and they knew what could potentially happen if they engage in this practice, and they still say do it.
So she basically opted into this insanity.
Yes.
So she could have left and got the hell out of town.
Yes. She knew the risk involved.
And she was probably just as happy last year when someone else was stoned, right?
Right.
Ooh. All right, so the breakdown here was 70-30. About a third of you put that it was not fair. I want to get someone who's the other perspective. I'm not sure if that will happen if I call on Max. Max, did you put yes or no? If you put yes, I'll come back to you later.
I put yes.
Okay, I'll come back to you in a minute. Who put no? You just please raise your hand. I want to get the other perspective, please. The third of you put no. Come on, don't make me check. I can check. Who put no? Okay, Matt, go ahead.
So I put no. It followed Denver's logic there, but it was hard for me to say that it was fair when the end result was so horrendous. Just because your name is drawn with the black dot does not justify or make it fair that you should have to die by stone.
Okay, so you're judging fairness based on the result, not the process.
Exactly.
So in other words, no matter how impartial the process was, Matt, you're saying that this cannot be a fair law.
It was really hard for me to say that it was, although I do think you could have a fair process with a...
Matt, let me ask you a follow-up. could you imagine if we had a criminal jury trial, right? And the judge, instead of putting the case to a jury, flips a coin. It's a perfectly weighted coin, 50-50 shot. Heads I win, guilty, tails you lose, innocent, right? Not guilty. Would that be fair? Completely fair coin, 50-50. No ifs, ands, or buts.
Yeah, I mean, it's really hard for me to say yes because it's not based on the evidence necessarily. But
So what you're saying is that a law is not only about, or a fair process is not only about whether the process itself is fair, that there's some sort of reasoning or some sort of logic behind it in order to make the process work. Is that what you're getting at?
I think so, yes.
Okay, Lainey, I think I saw your hand up for the no category.
Yes, so it's a fair process, but it's not fair that there was someone who got to decide for everybody that we were going to have that process.
What if we learn, and I'll just make up facts, that the town council voted on this and everyone in the town agrees, like, yep, we need this. Everyone agreed to this process.
If everyone agreed, then I suppose it's fair, and they're just crazy that they agreed to that.
So is a law fair because a simple majority agrees to it?
No.
I thought you said it was fair. Yeah. If there was a majority vote and a majority...
That's not majority. That's
Oh,
fair.
okay. What 51% voted for it? Does that make it unfair?
Which percent?
51%.
No.
So in our society, our laws only pass when 100% of the society accepts the law?
No.
When 100% of the members of Congress accept it?
We're not going to have a perfect process.
So, but we have laws that are passed with only 51%. That's all you need in our government.
I understand.
So how can you bind people who don't vote for laws? Is that not just?
It is because it's part of the process that you agree to be a part of.
I didn't agree. Did you agree to this process? I never opted in. No one asked my permission.
Well, that's what I'm saying. There were decision makers. However they got there, there were decision makers that came up with
made
it.
before Tessie was born. Decision was made before Tessie was even born. Her grandmother voted for it. I'm being
We're not
difficult.
born into the same opportunities. That it would suck to be born into that community where that's something that somehow decision makers decided and everybody is stuck with it.
Oh man. All right. Anyone else in the no category? Thank you, Lainey. Anyone else in the no category?
This is Kevin. I was in the no.
All right, Kevin. What's your view here? I've gone through a lot of stuff with Macy and with David.
I think I'm kind of probably in some of the same mindset of some of the other people that have talked, but I think I would even if the process you can say is unbiased, I don't know if that means it's fair per se. So arbitrarily pick somebody to die. I just don't think you make a fair argument of that. Even if it's randomly selected, I don't think randomness equals fairness.
Ah, okay. All right, thanks, Kevin. All right, so let's go back to, I think, Max, you were next on the queue.
Yes, I'm here.
Okay, so, Max, let me ask you a follow-up question. Let's move from the lottery and this sort of fictional world to the world we live in. How is a judge supposed to decide if a law is fair, or if a law is arbitrary, or if a law is reasonable? I know this sounds like a very stupid question because, reasonable person standard, right? How is a judge supposed to decide whether a law is arbitrary? I mean, what standards could a judge use to make that decision?
I think they compare it to the Constitution and whether it's at odds with that.
Oh, lovely answer. So the Constitution says the government can deprive a person of life, liberty, or property without due process of law. That's all it says. How is a judge supposed to know? Let's say Congress enacts a law tomorrow that says all criminal juries will decide by the flip of a coin. Completely fair coin, 50-50 shot. No bias. How is a judge supposed to know that that's constitutional.
You mean how are they supposed to know that that violates their due process clause?
Yeah, sure. Yep. How are they supposed to know?
I think because that could lead to being considered an arbitrary law
Okay, so how do you know it's arbitrary?
because of the randomness.
Okay, how do you know it's random? I know I'm being difficult, but I'm drilling down. How is a judge supposed to know that Congress acted in an arbitrary fashion? Maybe Congress had a better judgment over the way to dispense justice, right? How's the court supposed to second guess what Congress decides?
I don't know, common sense.
Common sense. Are judges supposed to use their own common sense over what the elected branches decide upon?
I don't believe so.
Ooh. Evan, does everyone agree on common sense?
I think the majority of people do.
Oh, I disagree. Take up somebody who just graded 120 exams. I disagree on that statement vigorously. Sorry, that was mean. I didn't mean to pick on you. My point is, different people disagree in many regards, right? Phrases like common sense and isn't that obvious and doesn't everyone agree? Look, my friends, there are 60 people in this room. We have 70 opinions among a lot of us. I would not pretend for a second to say that any of you have a better or worse opinion. We're all entitled to our own views. I mean that sincerely, right? And we all approach things differently, and that's what makes our world work. If everyone agreed with me, this would not be a very fun class. But at bottom, for a judge to say that this law is arbitrary is to tell the legislature, you know what, you screwed up, right? You thought this was a fair process. You thought this made sense, but you were wrong, right? This law makes no sense. And that creates a dilemma, right? Who is a judge to come in and say, you know what, this law was passed by Congress, signed by the president, right? Went through all the committees, did everything it's supposed to do, and it's arbitrary. There's no express text of the Constitution that's violated. It's not like, well, this is not commerce, or this is not a tax, or even this is not free speech. All you're saying is this law is not fair. How is a judge supposed to know that? This is the rest of our semester. The due process clause is very short. Right? It's very short. Right? It says, I'll put it in the chat so we can look at it over and over again. Nor shall any state deprive any person of life, liberty, or property without due process of law. Nor shall any state deprive any person of life, liberty, or property without due process of law. Taylor, are you here?
Yes.
Taylor, help me out here. What is due process of law? I mean, the last few words in that quote. What are due process of law?
Well, I jumped to criminal and think the process that has to be gone through to find someone guilty.
Well, no, just trying to. Due process of law. What do those words mean? Due and process and law. What do those words mean just by themselves? Try it like that.
A certain proceeding.
Okay. What kind of proceeding? Can you just flip a coin? Is that your process? You flip a coin where you draw a number of a hat. Is that a process?
I mean, technically, it's a process.
And what if that's the legislature adopts a rule that says we flip coins and it's a process according to law? Is that a due process of law?
I mean, it's technically a process, but it's not fair.
Oh man, where's the word fair? Does the F word appear in the 14th Amendment? Sometimes I want to say the F word in response to these opinions, but By the way, the word fairness, I call it the F word because I hate it. It's a meaningless word in my mind because everyone disagrees what fair means. There's if you have little kids, that's not fair. Everything is not fair to little kids, right? That's the only word they know. It's amazing. Kids know fairness at the youngest age. That's not fair, right? Taylor, the word fair is not in there. How did you just incorporate the word fair into the word due process of law? How'd you make that move?
I don't know.
I don't know. It's very natural though what you did. You did what judges always do. Thank you, Taylor. Who's next? Alexandra, you here?
Yes, I'm here.
Okay, so what does the word liberty mean in the due process clause, Alexandra?
I almost think of freedom in a way.
Okay. And how are judges supposed to know what the word liberty means in the due process clause?
Maybe by looking to other parts of the Constitution and just using it in that kind of context. Because the Constitution is supposed to, I guess, grant citizens.
Good answer. Okay, so where might you look in the Constitution to know what liberty means? You said look elsewhere. Where else would you might look?
The Fifth Amendment.
Okay, look at the Fifth Amendment. What's in the Fifth Amendment?
It said, in the notes it says, no person shall be deprived of life, liberty, or property without due process of law.
Oh, now you're just saying there are two due process clauses, aren't there? There's a due process clause in the Fifth Amendment, which binds the federal government. And there's a due process clause in the 14th Amendment, which binds the states. But you're not answering my question. How do we know what the word liberty means? Where might we look? I think you're on the right track. You might look somewhere else. Where might you look?
I'm not sure. It could be in the Bill of Rights.
Ah, good. Where in the Bill of Rights might you look?
I'm not sure. I guess just the entire Bill of Rights.
You're actually in the very right track. So, thank you very much. So one of the easier ways of answering my question is, as Alexandra just said, look at the Bill of Rights. The Supreme Court has held that almost the entirety of the first 8 amendments, not all of them, but most of them, are liberty. So, for example, the freedom of speech, the free exercise of religion, the right to keep and bear arms, right? These are all different types of rights recognized in the first 8 amendments. And the Supreme Court has held that these rights are considered liberty, right? And the due process clause of the 14th Amendment is understood to embrace these forms of liberty. Moses, I see you just in 1 second, I promise. So, the court has actually held that now the states are bound by the first 8 amendments. I'll come back to it in a minute. Yeah, Moses, what's your question?
So, my mind went back to the Declaration, and additionally, again, I remember teaching to students what was due process of law. And ultimately, I just landed on what the book said, fair trial or hearing, which meant fair meant equal. So in my own little construction or in my own little head, I went back to, here's a declaration, here's what the king did not do, and a fair trial will be, then a fair hearing would be everything the king did not do, we should do. So that's kind of where I landed there.
Okay, so what you're describing, Moses, is what you might call procedural due process. Right? There's a phrase which is often used called procedural due process, right? what sort of processes are necessary to deprive a person of his life, liberty, or property? So maybe a jury trial, right? Maybe a fair judge who's not biased. Maybe you'd have the right to select jurors from your community, right? Maybe you'd have the right to cross-examine your accuser. Maybe you have the right to an attorney. Maybe you have the right to obtain any evidence that the prosecution is using, right? These are all what you might call procedural rights, right? Procedural due process, right? If the government wants to take away your home, they have to have a trial before they can seize your house. If the government wants to introduce evidence against you in a criminal trial, there has to be a proceeding where the evidence was properly obtained, right? There are all these procedural rights. So in that sense, you're right, Moses, that there's a procedural component, right, to the due process clause, what's called procedural due process. Now you may say, Josh, wait a minute. Isn't that redundant, right? The word process is in there. Why do you need the word process twice? Why do you have procedural due process, right? The process, it's stupid, right? There's another label which you need to know called substantive due process. Substantive due process. Wait a minute, Josh. What are we talking about here, right? How can you have substantive due process? Isn't that an oxymoron? Justice Scalia described it as an oxymoron, right? How can you have something about process have substance to it? Isn't process the opposite of substance? Is that what you guys learned in Civ Pro and other classes, right? You have procedural rules and substantive rules. Welcome to the 20th century, my friends. In modern constitutional law, the due process clause doesn't only concern procedural rights, jury trial, fair judge, right? Confront your accuser, right? There also are substantive components to the due process clause. And the word liberty is where this comes into play. The word liberty is understood to mean not only just procedural rights, but it means free speech. It means free exercise of religion. It means the right to bear arms, right? That there are some rights that are so important that no amount of process can justify the deprivation, right? That the freedom of speech is so important that the states can't violate it with any amount of process, right? That this is a liberty that you have. The due process clause of the 14th Amendment is understood to embrace certain types of rights. No matter what process you're given, you can't violate those rights. So you might say, Josh, what the hell? This makes no sense, right? It says you can deprive someone of liberty if you give them process. That's what the thing says. You have to view the due process clause the same way you view the lottery case, right? The courts have said that there are certain types of rights that are just so important that no matter how fair the process is, it's still wrong, right? You know, let's say we had a rule that says we flip a coin. Heads, this person's allowed to speak his mind. Tails, that person's allowed to speak his mind. But unless you win a coin toss, you can't speak your mind, right? The freedom of speech is so important, it can't be left to chance, right? The freedom of speech is so important, it cannot be left to a random process. No amount of process can justify the deprivation of freedom of speech, right? This is the basis of substantive due process, right? When you have these liberties that are just so damn fundamental, so important, that you can't deprive people of them for any reason at all. Does that make sense? Moses, does that make a little sense? Or at least we get closer?
I think we're getting closer.
I'm not there, not quite there yet, but we're getting closer?
You're getting closer, I think.
Okay. All right, let me try it again then. Thank you, Moses. Right? When you think about the due process clause, you have to approach it from the context of two angles, right? One, what process they're being given, Is there a jury trial? Is you have the right to confront your accuser, right? But you also have to think about it that there's certain types of rights that are so important that it doesn't even matter what process you use, right? The government can't force you to worship some god that you don't believe in by merely flipping a coin. The government can't force you to worship some god you don't believe in by giving you a jury trial, right? What if you had a jury trial that said, okay, you're guilty of believing the wrong god, believe in this god now? That wouldn't work, right? You have a trial, you have a jury, you have a conviction, and the crime is he believes in the wrong god, right? That's your crime. What the courts say is this law itself is arbitrary, right? It's such a violation of what's in the Bill of Rights that it cannot be valid even with a jury trial. In other words, you can't take a random, unfair, unjust law and dress it up with a fair trial. The law itself is still void. And what the doctrine of substantive due process means is the courts are saying, do you have any common sense? Are you insane? This law is stupid, right? I know you enacted it, but you guys are a bunch of idiots. This is a bad law, right? With substantive due process, the courts are second-guessing the wisdom of the legislature. Now, some of these cases are easier than others, right? We have a Bill of Rights which says, the Bill of Rights says that you cannot violate the free exercise of religion. Okay, that's pretty easy to understand, I think. And if a law says that you're required to worship one god over the other, I think we could all agree that this law is inconsistent with a liberty interest as protected, right? It's not hard for a judge to decide that this is a law that's arbitrary, right? It's so patently unconstitutional. But what if we're not dealing only with rights that are written down in the first 8 amendments? What if we have a right that's not written down? To use a modern example. What if we say the Due Process Clause protects the right of marriage? Or a right to engage in sexual relations? Or a right to obtain an abortion? Or a right to obtain contraception? Right? Or a right to engage in an economic profession, to engage in make a contract, right? The word liberty is not only limited to the provisions of the Bill of Rights. The word liberty also extends to certain unenumerated rights. And that's where this case gets challenging. How are the courts supposed to know that a law is arbitrary, unreasonable, when all you have is the word liberty, and you don't know what that word means? You can get some good guidance for the provisions of the Bill of Rights, but what about a right of contract? The one at issue in Lochner and Muller, right? How are we supposed to know there is even a right of contract in the Constitution? How is a judge supposed to know that an economic policy is perhaps unwise or unreasonable or unjust when the legislature thought it was just fine? Moses, I saw your hand was up a minute ago. I didn't mean. I'm sorry if you dropped it, but I did want to come back to you.
No, I want to put it up because I didn't want to interrupt you. So I'm going to ask probably the most stupidest question that a 2L could possibly ask the professor. Maybe I don't know the definition of substantive here.
Oh.
So what is the definition of substantive?
You're right. It's not a dumb question at all. I did you not in CivPro the difference between substantive procedure? That never come up?
No, it actually did. And that's why I'm asking. That's what I'm saying. This is the most stupidest question a 2L
you're right. Okay. The word substance, right? Think of a container, right? You have a jar, and you fill the jar with a liquid, right? The substance is what you put into the jar, right? It's the content. It's what fills it up, right? So if you think of the Due Process Clause as like a jar or a bottle, right? What are you pouring? What substance are you pouring into the word liberty, right? You say the word liberty has substance, it has content, it has stuff in there, right? Does the word liberty, are we pouring in just the provisions of the Bill of Rights? Or are we also pouring in, these sort of unenumerated rights to contract, or rights to abortion, or rights to sex, whatever else? Does that clear up a little bit?
Yes, that clears it up a lot. You just described a dilemma that I've been in my head.
You know what? You're not asking a bad question. I always have to check myself and put myself in the shoes of a 2L and say, what do they know? And I made an assumption that in Civ Pro you learn what substance means, but I'm wrong. I guess that's not a safe assumption to make. But yeah, I mean, you're right. I confess error. I should have discussed that. Yeah.
We talked about it. It's just that
you have to find it
in law school that sometimes a word that I think I know, I actually don't know it.
Yeah, you're right.
And a word that's tossed around in common language in the law is totally different. And it could be one thing in one part of the law. It can be the word can mean totally something different in another part of the law. And so I'm having to always check.
No, I bet you there are 20 other people who are saying, "Oh God, thank you, Moses, for asking that question." Yeah. You know what? I'll make sure when I teach this again next year to do that better. I can do better. Yeah. Right. So the phrase substance refers to the content, the definition of what kind of rights are being put into the word liberty. Right? Is it just the provisions of the Bill of Rights, or is it also these sort of unenumerated rights? If all we're saying is the Bill of Rights are part of liberty, then that's an easy call, right? People aren't going to be too angry about that, at least anymore. But when we talk about economic liberty, which is the subject of a couple of cases today, it gets a lot more controversial. Okay. Now, the phrase substantive due process did not come around to the mid-20th century, right? It didn't exist, our cases there in 1900, 1920, right? It didn't exist in the first couple decades of the 20th century. So I'm describing a concept that wasn't really defined till later. As you often know in the Supreme Court, the court doesn't always say what it's doing right away. It only sort of becomes clear later. I think this is a good example of those cases. Okay. How are we doing? Okay? All right. We have 4 cases on the docket today. We have Lochner versus New York. We have Buchanan versus Warley. We have Muller v. Oregon. And we have Adkins versus Children's Hospital. 3 of these cases are no longer good law. Lochner is not good law. Well, actually, Muller kind of is. I'll say 2 of them. Muller is kind of a closer call. But Lochner is not good law, and Adkins is not good law. Buchanan is kind of good law, but for reasons I'll discuss later, not exactly. And Muller is good law for the wrong reasons. And I want to explain to this class why that's the case. All right, let's start with Lochner. I think Vanessa, you're on deck. I'll get you in a minute. Let me just give some background. Most ConLaw students learn that Lochner is one of the worst cases ever. If you read discussions about the anti-canon, right, you have Korematsu or Dred Scott, right, Plessy, right, these really, really, really unpopular cases. Most law professors will put Lochner in the same category as Dred Scott and Plessy and Korematsu. I am not one of those professors, but I do like to always give you the full picture. For a lot of law professors, Lochner represents what you're not supposed to do as a judge. The facts are pretty boring about, bakeries and who the hell cares about bakeries, right? But for a lot of law professors, Lochner represents the wrong approach to judging, where the legislature makes a decision about health and safety, and then the courts come and say, yeah, no, you can't do that. Never mind. Right? So the reason why people say that Lochner is anti-canon is not because, people are being thrown into internment camps or people, being separate train cars, whatever, right? It's because this resembles or embodies an approach to judging that's considered very bad. I personally think the analogy is insulting. I mean, to even put Lochner in the same sentence as Dred Scott, I think is insane. This is my own perspective. I'm sorry. I can't even countenance it, but that's the profession I work with, so I deal with it. I should also note that my professor in law school, David Bernstein, is the leading scholar on Lochner in the world. He was my professor, so I'm a little bit maybe jaded against the Lochner criticism. But Vanessa, let's go ahead and do the facts on Lochner, please.
Okay. So New York had a Bake Shop Act, which basically didn't allow people in a bake shop to work more than 60 hours in 1 week. And Joseph Lochner was convicted because he violated this act.
Okay, good. How did he violate the act?
He had an employee in there for longer than 60 hours in 1 week.
Was the employee forced there against his will? No. Was he doing it voluntarily?
I believe so.
Yeah, you're right. Okay. Thank you so much, Vanessa. I appreciate it. Okay, so the facts of Lochner are actually pretty straightforward, right? New York enacts what's called the Bake Shop Act, which regulates how bakers can operate. At the time, there were generally two different kinds of bakeries, right? You had these sort of commercial bakeries that had these facilities with these large ovens and the very precise equipment to slice the bread and everything else. And then you also had what you might call mom and pop bakeries, where you had an oven was in the basement of a building. And why was the oven in the basement? Because they were heavy. And if you put an oven on a floor, it can crack through the foundation. So you'd put the oven on the ground floor in the basement, and people would make bread. Now, maybe you've made bread, maybe you've not, but bread making is a very time-consuming skill. And the reason why is you have to wait a lot, right? So first you make the dough, you put the yeast in, right? And the yeast is a reactant, it lets it rise. And that can take an hour. And you have to knead the dough, then you have to let it rise some more. You have to let it bake, and that might take an hour. And then you have to let it cool off, and that maybe take some time as well, right? So baking is a very time-consuming process in that there's a lot of space between your steps. So a lot of immigrants took to baking as a profession because it could be done fairly cheap. It didn't require a lot of capital, and you could basically stretch the day out. So you knead the dough, then maybe you take a rest, then you do this, you take a rest, right? It was a very lengthy job. New York found a problem. A lot of these bakeries were in cramped spaces and had sanitation issues. The Bake Shop Act had a number of laws governing the cleanliness, governing animals and rodents in the workshop. Right, there were a lot of laws that were passed in the Bake Shop Act that regulate health and safety. The Supreme Court says all those are fine. Right, people think, the entire Bake Shop Act. No, they only looked at part of it carefully. But the portion that the court focused on was the restriction that Vanessa mentioned, that bakers can only work 60 hours a week. And that was in one bakery. They got around this quickly. They just worked in a second bakery for more than 60 hours. I mean, look, if you were a poor immigrant here, you found a way to work more than 60 hours. This wasn't like a death sentence. You found a way around it. But there was a test case where Joseph Lochner employed his employee, his name was Armin Schmitter, for more than 60 hours a week. This was what you call a test case, right? Where the baker wanted to challenge the law because it was basically hurting his business. He couldn't employ people to work enough hours. Okay, again, all of the justices agreed that the health and safety regulations were valid. The only dispute was on the what do you call it? Was on the a 60-hour maximum hour law, and the courts put 5-4. 5-4. Now, Justice Peckham wrote the majority opinion. He was joined by Chief Justice Fuller, Brewer, Brown, and McKenna. So it was 5 votes to the majority. Justice Harlan. Yes, the same Justice Harlan keeps popping up. Justice Harlan wrote the principal dissent, joined by 2 others. The majority and the principal dissent agreed that the word liberty includes the right of contract. Right? So 8 of the 9 justices agreed that the word liberty includes the right of contract, the right to work according to the conscience of your own dictate. In other words, the government can't, violate this right. They all agree this right exists. Where the majority and the principal dissent disagreed was over whether this regulation was reasonable, whether it was fair, whether it was arbitrary. See that these words come back into play, right? The majority said this was an arbitrary law. There is no reasonable ground to interfere with the right of contract. Why? The majority says this law was not fair. It was not reasonable. It was not appropriate. Bakers, the court says, was a safe profession. Right? Bakers was a safe profession. It wasn't dangerous. The government had no reason to restrict. Right? The government had no reason to restrict how many hours bakers work because it's a safe profession. In fact, the majority says this law wasn't aimed at health and safety. It was aimed at helping the labor unions, which is probably right, but secondary to the analysis. Okay? Justice Harlan, who wrote the principal dissent, disagreed. He says, look, there's lots of evidence to show that baking can be dangerous. Right? He had all these statistics which showed the regulation was arbitrary. It was not arbitrary. According to the dissent, Lochner didn't meet his burden of proof. Right? The dissent, Harlan says, Lochner, you have to show us this law is arbitrary, and you've not persuaded me. And because the law was not arbitrary, it was upheld. Macy, go ahead.
Do all liberties fall under substantive due process?
What do you mean, all liberties?
Okay, so when we define substantive due process, you said it was a right that you couldn't take away. It was so important that no amount of process could take it away. But if liberty includes the right to contract, then why does the majority talk about whether it was reasonable or not? That kind of insinuates that if it was reasonable to restrict, then they could restrict it. So I'm just confused.
We will spend, Macy, the rest of the semester deciding what is liberty for purposes of the due process clause. There's no good answer to your question.
That's unfortunate.
Oh my goodness. You're like I told you, you're gonna just miss like, oh my god, commerce is a thing we can actually latch onto, right? Liberty is just this sort of concept that's like blah, right? It's like whatever you want it to be. You can pour whatever wine into the bottle you want, to use the analogy, right? You can pour whatever substance you want in there. And different judges pour different stuff in there. It's a strange brew. All right. So both the Harlan dissent and the majority by Justice Peckham agree that there is this right of contract, but they disagree whether it's arbitrary. According to the majority, the state did not show that this was a really just law, right? They didn't have enough evidence to show that they really needed this. And the Harlan dissent says, no. It's not the state's job to defend it. It's Lochner's job, right? And Lochner can't show me this is arbitrary because there's all this evidence showing baking is a dangerous profession, right? Anyone ever work in a bakery? You should have at least one or two. It's actually hard work, right? There's the flour in the air. There's the hot oven, right? There's the rolling. There's a lot of work. It can be a very stressful job. But the majority in dissent disagreed on a fairly minor point. Then we get to Justice Holmes. Justice Holmes is very famous. I'm sure you read his opinions in other classes. I am not a Holmes fan for reasons that will become very clear this semester. I am very critical of Holmes. I think he's very, oh my God, very overrated. If you think I'm a Roberts critic, I'm a bigger Holmes critic. Holmes says, look, none of this crap matters, right? It doesn't matter whether statistics cut one way or the other, right? He approaches this case with a method of deference. What do I mean by deference? What Holmes says is if the New York legislature thought this law is reasonable, it's good enough for me. If the people of New York elected their members to the legislature and they thought this was an important law, who am I to second guess? Right? Who am I as an unelected judge to tell the people of New York that your legislatures are idiots, that they enacted an arbitrary law? Because think about it, right? The majority is saying to New York, you guys are a bunch of dunces. You enacted a stupid arbitrary law and we know better, right? We know better than you know. So Holmes articulates this method of restraint where the courts will not second guess democratically enacted legislation. And you might think, oh, wow, that's awesome, Holmes. You go, Holmes, that's awesome. Then we get to Buchanan in a few minutes, right? Then you look at his dissent, and it's like, wait a minute, whoa. So the Holmes mantra of deference looks great when you like the law, and it doesn't look so hot when you dislike the law, right? That's the rub of Holmes, right? He has at least the virtue of consistency, which I suppose is a virtue, right? He sort of strikes the same position in just about every case. Let the government decide whatever it wants to do. But when the law in question is quite awful, which we'll have a few of those, Holmes doesn't look so hot. Holmes also has a very famous analysis. I just want to read a few sentences. He says, the majority decides the case on an economic theory called laissez-faire capitalism. And he says, not everyone agrees with laissez-faire. What's laissez-faire? It's sort of like how to describe that being. Laissez-faire is French, means basically hands-off, right? Where the government does not intervene in industry and they let the businesses run their own show. And he says, look, a lot of people don't agree with laissez-faire capitalism. And the 14th Amendment was designed for people of different perspectives, right? The 14th Amendment was designed for people of different views. And the 14th Amendment should not adopt any one economic theory. He mentions Mr. Herbert Spencer's social statics, a very famous line. Who the hell is Herbert Spencer? He was a famous economist from the 1800s. Not very important who he is. But Holmes is very adamant. He says, we should not be deciding cases on economic theory. That's not our job. We should be deferential to the elected branches. All right. This is a poll question of just opinions. There's no right or wrong answer. For question number 4, multiple choice, which opinion, Lochner, did you find the most persuasive? Justice Peckham's majority opinion, Justice Holmes's dissent, or Justice Harlan's dissent, A, B, or C? Fascinating. All right, another 5 seconds or so. Okay. So, about 40% of you put the Peckham majority. About half of you put the Harlan dissent. And about 10% of you put the Holmes dissent. Fascinating. No right or wrong answer. I'm always curious how this breaks down. I'm with Harlan, as usual. That's usually where I fall. Not always, but I'm usually with Harlan. But I go back and forth. I can see the Peckham. I can go both. But very few with Holmes. Fascinating. Okay. So the upshot, though, is that today, for these sorts of economic liberty cases, Holmes prevailed. The Peckham view predominated for about 20 or 30 years, depending how you count, in the early 20th century. And if in the 1930s to the 1950s, Justice Harlan prevailed. But after the 1950s, we went full Holmes, and they haven't gone back. So you'll see throughout the 20th century different eras where they apply different tests. None of this will make sense quite yet. You'll get it more in the next few weeks. But the Peckham opinion had a good run, and it sort of fell out. And the Harlan opinion had a good run, and it fell out. And by the time you get to the 1950s, eventually the court adopted Justice Holmes's approach. We will come back over and over and over again to the Peckham, to the Harlan, and to the Holmes opinions, just over and again. Because, I mean, this case summarizes so much about constitutional law, right? The majority would put the burden on the government, right? The government must defend its law. Justice Harlan would put the burden on the business owner to explain why this law is irrational, right? And then screw it. Justice Holmes is like, I don't care. If this is enacted law, it's good enough for me, right? In constitutional law, whoever has a burden of proof usually loses. If the government has a burden of proof, the government's probably going to lose. If the business owner has a burden of proof, he's going to lose. Generally, when the court says you have the burden, you lose. So much of constitutional law is putting the burden on the other side. Whoever else the other guy is, you give him the burden. That's generally a very common approach in ConLaw. Okay. Questions on Lochner? Let's do Muller. A little bit of order, because I think it makes a little bit more sense. Let's do Muller v. Oregon next. Okay. Muller was a bit of a different case than Lochner. In Lochner, you had a maximum hour law for male workers. Muller was a maximum hour law for female workers, no more than 10 hours a day. Now, why did Oregon enact this law to restrict how many hours women could work? The answer wasn't necessarily for their health and safety, although it kind of was. The answer, to be frank, was based on the notion that women should not be working, that a woman's place was in the home. Think of Bradwell v. Illinois. Remember that with the lawyer case? And the thinking was that women shouldn't work so much. How do we know this? We look at their brief. When this case went to the Supreme Court, there was a very famous brief filed by Louis Brandeis. You might know the name Louis Brandeis. He became a justice later, appointed by President Wilson. But at the time, Brandeis was a very famous progressive litigator. And he argued in defense of progressive laws that regulated health and safety. And Justice Brandeis put in a brief to the Supreme Court that, I mean, you can read it. The PDF is available online. It's just stunning. I've seen the excerpts in the introduction book. But like the stuff he wrote was just utter nonsense, even at the time. My favorite line. I mean, I'm not joking. He actually wrote that if women work too much, their uteruses will fall out. And in order to preserve the species, to have women reproduce, we shouldn't have them work to because then they'll lose their uteri. I guess uteri, right? Plural of uterus. I'm not making this up. You can go check me on this. I wish I'm making this up. He wrote things like, women have more water in their blood, and they're inferior, and there too many hours will make it that they can't reproduce. It has effect on the reproductive functions. We need to protect the species so we can't have women work. Just even at the time, this was nonsense. But why was he doing this, right? Why was he putting all these, Ronda Rousey, yeah. Why was he putting all this nonsense into a brief? Because under the Harlan approach, right, if you have evidence to show the law is reasonable, that it makes sense, then the law is valid. And this happened to be a unanimous case, 9-0. Right? All the justices agreed that women could have their hours restricted. Not even a couple years earlier, 3 years earlier, you had Lochner. So I think, again, you're seeing a similar split from Slaughterhouse to Bradwell, right? With the male butchers to the female lawyers. And here you have the male bakers to the female laundry workers, right? The court applies a double standard. Now, I said at the outset, is Muller good law? Okay, so yes and no. No, it's not good law because today gender discrimination is unconstitutional, right? You can't have one set of rules for men workers and another set for female workers. So Muller is not good law in that regard. But, and here's a caveat, the big but, Muller does represent a better approach than Lochner, right? Because in Lochner, the court was not deferential to the state, whereas in Muller, the court was deferential. They said, okay, you know what? You want to preserve the uteruses, you can shut down women working. So, in the same regard, Muller is inconsistent, but is still looked upon somewhat favorably. Funny story. When I was still in law school, I went to law school in D.C., and the Supreme Court has these reenactments where they reenact very famous cases. They have like an oral argument, and they have a sitting justice actually preside and ask questions of the lawyers for a very famous case. And one year, it was actually Muller v. Oregon, and it was actually Justice Ginsburg who presided over Muller v. Oregon. And this was, she was very, very crafty. She was sitting here arguing about Lochner and saying, well, isn't it dangerous to women to have them working so many hours? It was just hilarious to hear her just playing this role. She played the role very well. This is in 2008 or 9, so some time ago. I heard Justice Ginsburg defending Lochner for a few minutes, which was sort of surreal, but it was fun. All right, questions on Muller. Muller against Oregon. Okay. Let's now do Buchanan. Buchanan v. Warley, 1917. This is a case that most people have never heard of. In fact, in most ConLaw case books, it doesn't appear. Indeed, in Randy's book, before I got there, it didn't appear. I made him add it because I thought it was a very important case. And the reason why I think Buchanan's an important case is it shows how the Due Process Clause was used in the wake of Plessy, right? Plessy upheld the separate but equal doctrine. That was the law. The city of Louisville enacts a law that basically makes it impossible for a white person to buy a home in a black neighborhood. It also makes it impossible for a black person to buy a home in a white neighborhood. So, separate but equal, right? Black people live here, white people live there, everything's fine. Under the rule in Plessy, this law was valid. So, the civil rights groups who brought this case made another argument. They argued due process. They argued that there was a liberty interest to buy and sell property. They argued Lochner, right? This was a liberty interest. And the court actually went along with it, right? The court unanimously, we'll get to the dissent in a minute, the court unanimously agreed that the Louisville segregation law violated the Due Process Clause, right? That this was arbitrary, right? That it was preventing someone from buying property based on their race. And this was a arbitrary law. Right? You cannot discriminate against a person based only on the color of their skin. Wait a minute. How the hell do you square that with Plessy? Right? How do you have these sorts of statements and Plessy being good law, right? What you're starting to see is the court is chipping away at separate but equal. They recognized that that was even a mistake, even by the 1920s, right? When this came, 1917, they knew Plessy was not going to stand well. So what you start seeing is the court chipping away. They don't overrule it till well, if they overrule it, but they don't ever say it was wrongly decided until much later. But here in Buchanan, they start to chip away at the Plessy rule. And they apply the saying, look, this is, the law was enacted. It might be, fair in the sense of black can't live with white people, white can't live with black people, whatever, right? But it's an arbitrary law. There's no good reason why a person's skin color should dictate what properties they purchase. But then we have Justice Holmes. Yeah. And this was not well known. I only learned about this a couple years ago. He had written a draft dissent, right? The justices would write a dissent, and he circulated it. But no one was willing to join him. He couldn't get another vote. Holmes's dissent was like, look, we need to be deferential, right? The same thing he said. Oops, dropped the thing. The same thing he said in Lochner, he said here. It's not our role to second guess the legislature. If the people in Kentucky thought that there was a good reason to have black people living separate from white people, and that's their decision. It's not for us to second guess. The state has a police power to regulate the health, safety, and welfare of the people. Who are we to decide, if they're right or wrong? Indeed, Holmes seems to suggest that the white plaintiff here should not have been there. In other words, the 14th Amendment was designed to protect black people, but was not designed to protect white people. This view, was not unheard of. A lot of people said that it's insane to have a white plaintiff coming into court on behalf of a racial segregation ordinance. Now, the NAACP picked a white person deliberately to make it easier for the court to rule. They thought, well, if there's a white plaintiff, it's easier for the court to rule for him. And then Holmes flipped, saying, no. I won't rule for him either. Right? Holmes, though, withdrew the dissent because he couldn't get anyone to join him. He didn't want to be by himself. All right, he went along with it. So at least on paper, Buchanan was a 9-0 case, but we know internally that Holmes was very upset about it. All right, questions on Buchanan? Anything on Buchanan? Very important case. Yes, Lainey, go ahead.
So, in Holmes' dissent, which was not published, but we have it, he questioned if this was a manufactured case, which all these test cases are manufactured. I mean, something really happened, but a bigger entity like the NAACP is going out and looking for that instance
Correct.
so that they can bring the case.
Yeah.
So does the Supreme Court frown on that, or did only Holmes frown on that?
Most cases that you find are test cases, right? And I think the court is aware of it. I think what really miffed Holmes in this case was the fact that it was a white plaintiff, right? It was so obviously a test case because they didn't bring... Look, the reason why this ordinance was enacted was to keep black people out of white neighborhoods. Let's just be candid, right? But that was not how the case was brought. The case was brought because you had a white plaintiff who wanted to move to a black neighborhood. In a couple of weeks, we'll have a case involving gender discrimination, which is a little bit similar, where you had a statute that allowed women to buy beer at 21, but men could buy beer at 18. So actually women were treated more favorably because they're considered more mature. People are smiling, okay, whatever, we'll get there later. And there was a dissent, I think it was by Justice Rehnquist, who said, wait a minute, this is nuts, right? If we're talking about sex discrimination, right, you know what? This is about helping women, right? I don't want a man coming to court saying, oh, I can't buy beer at 18, I'll buy beer at 21, right? And Rehnquist was actually annoyed that the plaintiff was a guy instead of a girl, right? He said that this is about helping women. If women get a benefit, so be it. So it's almost the opposite of the Muller approach, right? Where women were getting a benefit, and Rehnquist was like, why are we, isn't this good that women are getting a benefit? Why are we complaining about it? So the sentiment that Holmes expressed was not novel. And it does come a lot, like, or the flip side is, in affirmative action cases, we have a white plaintiff, right, where a white student says she's being discriminated against by a policy that favors African American students, right? That's a Fisher case. It's like, why is a white student coming to here complaining about racial discrimination? Really, we should be worried about, African American students who are complaining about discrimination. So what Holmes is conveying here is not unique to this context. It comes up over and over again. Make sense? Any other questions on the Buchanan case? A very important case. It's not in most case books, which I regret, but I'm glad it's in ours. Perks of being a professor's student who writes the book, All right. So let's do the next case. I guess the last case. We say Adkins versus Children's Hospital of the District of Columbia. At the outset, this is a federal case. It involves federal District of Columbia. Why is that important? It's important because we're not talking about the 14th Amendment, right? The 14th Amendment controls state action, but no big deal. The 5th Amendment controls the federal government, and the 5th Amendment has a due process clause. Okay, so in this case, we have not a maximum hour law, but a minimum wage law. And again, it's a minimum wage law only for women. I'll be a little bit more crass here. These sorts of laws actually made it harder to employ women. Let me explain why. Let's just say the minimum wage was $1, make it easy. If a woman had to be paid $1 for a wage, but you could pay a man 75 cents an hour for a wage, businesses would be more inclined to pay the man the wage. On their face, these laws look like measures to help women. And in many cases, they may have. But in other cases, the inability to negotiate on a wage made it less likely women will be employed. Not always the case. In some cases, the wages were perhaps too low anyway. But often wages that are minimum eliminate the ability to negotiate a contract. Now, why am I making this point? The Children's Hospital actually sued to challenge the constitutionality of the minimum wage. And the hospital said, we want to be able to negotiate with our female employees, and we can't with this statute, right? So therefore, this law violates our liberty of contract. That is, the hospital's liberty of contract to negotiate wages. Okay? Everyone with me. The court declared this federal minimum wage for women unconstitutional. The vote was 5-4. Justice Brandeis recused. I think the story was that his daughter worked for the D.C. city government. I'm pretty sure I'm right about that, but I don't remember 100%. And this case has two angles, right? One angle is gender equality, and the second angle is right of contract. And this case always leaves my students with their heads spinning because they're like, wait a minute. I really like the things Justice Sutherland said about gender equality. I really dislike the things he said about economic liberty, right? So wait a minute, how do I spin my head around this? It's this strange dynamic where sometimes when you have equality, things are less fair, right? To actually treat the sexes equal means sometimes there are fewer benefits for the sexes, right? To use the beer example I gave a minute ago, if you want to treat the sexes equal, that means girls can't buy beer at 18 either. They have to wait till they're 21 as well, right? You level up, right? You can't give the women a benefit. So here, according to Sutherland, women have made great strides. They gained the right to vote. They began to participate in the political process. It's demeaning to women to say that they're inadequate, right? It's demeaning to women to say that they cannot bargain on their own, that they don't have an equal right to bargain, okay? The consequence of that decision is that women can bargain on their own, but they don't. They're stuck with low wages. And there was a political cartoon, I think it's in your book, that says that there's a constitutional right to starve, which I think was a very funny way of describing it. Justice Sutherland had been very active in the suffrage movement, and he had helped introduce the 19th Amendment in the Senate. He says there have been revolutionary changes in the status of women. He discusses this ancient inequality of the sexes, which we talked about in Bradwell. He's like, look, that's diminishing with intensity. Query whether he was being a little optimistic, but he believed it. I think he firmly and honestly believed that the distinction between men and women were fading. We'd come a long way since Bradwell to now having a majority of the court saying this, right? This was the first major decision of the Supreme Court that actually even hinted at gender equality like this. It was actually revolutionary that you got 5 votes for this. As a result, he says this law is based on a stereotype that women are inadequate, that they can't negotiate on their own, and that's not a justifiable stereotype. He says this law is naked, arbitrary, exercise of power, and it's unconstitutional. The Adkins approach follows the Lochner majority, where the government has to defend its law. And if the government cannot defend its law, then the law is viewed as arbitrary and unconstitutional. Justice Holmes dissented once again. I mean, this guy dissents in every case. In this semester, it's Holmes, right? He dissents in every case. And Holmes says, Taft dissented as well. It was a very short dissent, but Taft's like, let's just be deferential. Let's not do Lochner. But Holmes is very angry. He says, look, this law is permissible. When the people in government have studied this law and they've decided it's reasonable, that is good enough for me. Right? It's not for us to second guess what a reasonable law is. And Holmes basically repeats his Lochner dissent. All right. I want to do a poll as well to see how people think about the about the Muller opinion. So let's look at question number 7. Which opinion in Adkins do you find most persuasive? Sutherland's majority opinion, Chief Justice Taft's dissent, or Justice Holmes' dissent? Wow, look at that. Stop it here. Almost 2/3 of you agree with Sutherland. Fascinating. About the same 18% for Holmes. For Taft and 16% for Holmes. Fascinating. Okay. Questions on the Adkins decision? Questions on Adkins? Adkins is another good law. It'll be overruled barely about 10 years later, in 1937. So it's another good law, and we'll discuss why it's not a good law. But it was a significant decision precisely because it showed that this Lochnerism, as it's called, the Lochner era, wasn't only about helping one group, right? Buchanan showed that this doctrine of economic liberty could be used to help racial equality issues. And the Adkins case showed that this doctrine could be used to help gender equality issues. It's sort of a lost history of this doctrine. It's often viewed, these were anti-business interests, which is true, they were. But there was important ConLaw going on behind the scenes that most people miss. All right. Let me try to wrap up a bit, and I'll let you guys out of here in a moment. I'll put the minute poll on as well. This new topic we're starting about economic liberty, about modern substantive due process, is very controversial because the words liberty of contract appear nowhere in the Constitution. It just doesn't say it, right? How are judges supposed to know that the right of contract is protected? Well, most people in Lochner agree that it was. Okay. then how are you supposed to know that a law is arbitrary, right? That a law is random? Who has the burden, right? Does the government have the burden to defend their law? That's what Lochner said. Does the business owner have the burden to challenge the government's law and say it's arbitrary? That's what Justice Harlan said. Or is it just that any law enacted is reasonable and the courts defer to that reasonable law? And that's what Justice Holmes said. So these three opinions, the Peckham, the Harlan, the Holmes, will keep coming back to over and over again. At least throughout the Adkins case, Holmes was wrong. He was in dissent. But the Peckham opinion still carried weight. All right. Questions? All right. I'll be back here on 12:30 after office hours. Have a lovely day, and I will see you all on Wednesday.